Hello, I'm Paul DeCamp with Epstein, Becker, Green. Here at EBG, we're experiencing many of the same challenges as other businesses across the country. Most of our people are still working remotely. On a normal workday, we have more than 100 lawyers and staff on site here at our Washington, D.C. office. But because of COVID-19, I'm one of only about 10 individuals physically in the office today. And this is the first time I've worn a tie in about 4 months. Obviously, a lot has changed in 2020. I'd like to take a few minutes to talk with you about planning for a successful return to work. Specifically, my goal is to help keep your transition out of the shutdown or work from home reality that so many businesses have faced these past few months from giving rise to a wage and hour class action. As your workforce returns to working at your offices, plants, laboratories, stores, warehouses, or other facilities, you'll want to keep in mind a number of important issues that, if mishandled, can give rise to costly and distracting class litigation. The first issue is the cost associated with personal protective equipment and other materials associated with enhanced safety precautions, things like masks, gloves, and thermometers. In short, who pays for it? About a third of the states, as well as some local governments, require employers to provide or to pay for PPE. Some of the larger states that take this approach include Arizona, California, Illinois, Michigan, New Jersey, New York, Pennsylvania, and Washington State. What if you require at-home temperature checks and an employee doesn't own a thermometer? I recently bought one of those digital devices that you point at your forehead, and it cost about $50 on Amazon. If the employees are paying for those, and you've got a lot of employees, that could be pretty expensive. Depending on all the circumstances, including an employee's overall earnings, an employer may have an obligation under federal law to pay for some or all of the cost of these items, even if local law has not specifically addressed this topic. The important takeaway here is that employers need to think through this issue before employees incur expenses, or else you lose the ability to manage and to control these costs. Next, for non-exempt employees, consider the compensability of pre-shift temperature screening or enhanced sanitizing. Under federal law, the main case that's going to drive much of that analysis is Integrity Staffing Solutions against BUSC. That's a 2014 decision from the US Supreme Court. And in that case, the court concluded the time that workers spend in line and passing through post-shift security screening at an Amazon fulfillment warehouse is not compensable work. We've not yet seen cases applying that standard to COVID-19 screenings at the start of a shift, but we expect this issue to land in the courts soon. The basic question is going to be whether these types of screenings constitute a principal activity sufficient to start the clock for the day. Another factor to consider is that the courts applying the laws of a number of states have rejected the conclusion that the US Supreme Court reached in BUSC. For example, the California Supreme Court, as well as federal courts applying Nevada and Arizona law, have recently determined that post-shift security screenings are compensable activity. They do count as work in those jurisdictions. And the Pennsylvania Supreme Court is currently considering the same issue as well. Although questions arise regarding whether this activity is work, another facet of the issue is the availability of what's known as the de minimis doctrine or the de minimis exception. That's a principle whereby employers are not normally required to keep track of tasks that take a few seconds here or there, or a few minutes here or there. And if the increments of time are small enough or difficult enough to record, under some circumstances, they don't count as work and the employer doesn't have to pay for that time. There are issues with that, though, including the US Department of Labor taking the position that if an activity, even if it's very short in duration, happens every single day as part of the workday, then the employer needs to account for and pay for that time, even if the time is de minimis. And then some states reject de minimis entirely. So there are going to be issues regarding de minimis time. The thing to remember is that the facts matter quite a lot in these circumstances. For example, consider employees simply walking past or through a machine that scans temperature versus a more involved process, as well as any time spent waiting in line. When we think about what our clients are seeing as employees begin to return to work, many of these entities have some kind of temperature screening in place, and oftentimes it's a supervisor standing there with a thermometer that will scan somebody's forehead. If you have only a few people coming back to work, 5 people, 10 people, and 1 or 2 supervisors with these thermometers, this might be pretty quick. Or if people are passing through a machine that looks kind of like what you have at an airport for TSA screening, it's passive, it's quick, and it's not really taking people any more time than if they were simply walking through the entrance to the building. But think about what happens as more people are returning to work. You might have, instead of 10 people, 50 people or 200 people coming on shift at the same time, or perhaps more. If you have the same setup where it's one supervisor or two supervisors with a thermometer, even though for any particular individual going through the screening, the actual time required to take the temperature may be short, there may be quite a bit of time in line. And so you're going to need to keep in mind not just how the facts look today as people begin to come back to work, but think about how those facts might change as you ramp up back to a normal staffing level, if that happens. And if you decide to treat that time as compensable, which we generally do recommend, and as many employers are doing today, how are you going to record that time? Are you going to have people clock in before they begin the screening process or adjust their arrival time? Or are you going to add a certain number of minutes before the clock in? It's important to think through those issues about how you account for that time. Another thing to consider is that if you pay in rounded increments, like a quarter or a tenth of an hour, you'll need to think about how, if at all, the screening and the time that you're paying for that screening intersects with your rounding practices. Third, if you operate in a jurisdiction that has requirements for reporting time pay or show up pay, make sure that you understand what your obligations are if an employee arrives at work and fails a health screening. Let's say they get their temperature taken and it's 102 degrees. You're going to send the person home. Do you perhaps have to pay for the shift or some portion of the shift that the employee otherwise would have worked? The answer may depend on the nature of the screening, then current CDC and state guidance and standards, your policies, and what you have communicated to your workers. This is something where you don't want to be surprised after the fact with a lot of employees making a claim that you should have done something differently. You want to deal with it on the front end. Next, you're going to want to keep in mind any notices required under state or local law regarding changes in pay rates or work schedules, as well as predictive scheduling laws that apply with some industries in certain jurisdictions. For example, employees who received a pay cut or who got moved from full-time to part-time may now find that their pay rates partially or fully getting restored to their pre-COVID state, or their schedules increase back from part-time to full-time. You might have salaried employees who became hourly while things were slow and may again be moving themselves or be getting moved back to a salaried status. In a number of jurisdictions, notice of these types of changes must get to the employees, it must be in writing, and it must precede the changes by a week or sometimes several weeks. Very important to know what the requirements are in your jurisdiction for these changes. In addition, if you bring a salaried employee back from furlough, or if you change an employee from non-exempt to salaried exempt, it's best to try to time that change from whatever the pre-existing status was to salaried exempt. Have that change occur at the start of a new work week so that you avoid any issues regarding whether the employee has properly received a salary. The next issue is it's important to be mindful of any changes in job duties or responsibilities that may affect an employee's exempt status. Consider a few examples. There may be staffing changes that cause managers or supervisors to have fewer than 2 full-time equivalent direct reports. That could jeopardize an executive exemption. Exempt personnel may find themselves spending more time on non-exempt work than in pre-COVID days if there are fewer non-exempt employees around to handle the workload. Outside salespeople may no longer be meeting face-to-face with customers away from your place of business on a regular basis, opting instead for virtual meetings via Zoom, Teams, or a similar platform. If they're not having that outside activity, then potentially the outside sales exemption might not be available. Technology coupled with the pandemic may be converting outside salespeople into inside salespeople. Now, recent guidance from the US Department of Labor suggests that pandemic-related temporary use of exempt employees for non-exempt roles may not affect exempt status, but it remains to be seen what kind of reception that view from the Department of Labor is going to have in the courts, many of which have been unwilling to defer to this administration's wage and hour interpretations in recent years. It is also unclear whether the states will follow this federal guidance in construing their own state overtime laws. Realistically, assigning exempt employees to non-exempt roles for a week or perhaps a few weeks because of the COVID emergency may not present a high risk of litigation, but using exempt employees for primarily non-exempt work for extended periods of time can lead to litigation, and it's something we would strongly discourage. Finally, be careful about looking for non-employee solutions to manage these workplace concerns. In uncertain economic times, many companies find it tempting to turn to independent contractors or staffing companies rather than onboarding employees. That approach may address some of your business issues, though it can also potentially lead to lawsuits contending that you are an employer or joint employer of these workers. In that event, You may face the same wage and hour claims, but with much less ability to control compliance and to manage your exposure. It's important to remember that in wage and hour law, there really is no free lunch, and most attempts to outsmart the various requirements of these laws just tend to create other legal challenges and liabilities. Your best path for avoiding class action liability is to focus on developing solutions that comply with these laws, rather than seeking ways to sidestep the legal requirements. If you pay attention to these various concerns, you'll go a long way toward reducing your risk that your team's return to work will lead to a wage and hour class action. If you would like more information about any of these issues, send us an email or give us a call. We can do a video conference just like this webinar. No tie required. Thank you.